Hello, and karibuni, as we say here in Nairobi, Kenya, on this cold September evening. Thank you for taking time to spend an hour with on this. Today's show is about dispute resolution, commonly known as ADR. Conflict is a constant and a significant component at work, home, business, or the political environment. However, conflict can be handled in positive ways, whether it be through reducing tension, focusing on common goals, or through capitalizing on opportunities to make a substantial change for the better. So tonight we've got the experts, and we'll start with the ladies first. We have Mercy Okiro, we've got Ms. John Ohaga, and Lawrence Muiruri Ngugi. And of course, our host, Waweru Njoroge, with Mr. Mumo in the background, who's assisting us, controlling the platform. Habari zenu. How is everybody?
We're well, thank you.
Waweru.
Yes, sir.
How have you been?
Good. We need to unmute the mics for Lawrence and John.
I have done that.
And I just realized that was a new intro. We've never used that one before. That was cool.
Which one? The countdown?
The one that, yeah, the countdown clock thing. That's new.
It's a dynamic things. It depends on the mood. You wake up creativity to get a little creative spark. Yeah. Sawa, take over.
Right. Thank you so much. Thanks, Martin. I'd like to say a very warm welcome to all our viewers out there, and especially to our guests who are in studio. As Martin said, we've got John, Mercy, and Lawrence. I'm going to ask them to introduce themselves. I'm going to start ladies first, as always. Mercy, could you just tell us who you are, what you do, and why you're here?
Okay. My name is Mercy Okiro. I am an advocate of the High Court of Kenya. I also practice as a mediator, arbitrator, and I also dabble a bit in construction adjudication. I also train in arbitration and mediation for the Chartered Institute of Arbitrators, London, and by extension, all other branches, especially the Kenya branch. I also do a lot of work around gender empowerment, youth issues, and I sit in KEPSA boards. I think gender, youth, yes, and sports, arts, culture. I'm also involved in issues of KEBS, tourism, standard setting. I mean, also in that committee. And yeah, for now, I guess for the purposes of this conversation, that is what is relevant. The rest is available on all over my Twitter, my LinkedIn, and even my general social media. And I'm happy to be here. I'm here to try and sensitize rather the viewers and people who attend this session on ADR and what they can benefit from it. And I look forward to having a very informative and engaging session. Thank you.
As do we, Mercy. Thank you so much. Lawrence, please let us know who you are, what you do.
Thank you. Thank you, Waweru. My name is Lawrence Ngugi. I am an advocate of the High Court of Kenya, an accredited mediator and arbitrator. For purposes of today's talk, I'm delighted to be part of this. CEO, Nairobi Center for International Arbitration, a dispute resolution service provider, which specializes in all forms of dispute resolution, apart from litigation, which you find in court. So as we discussed today, mine is to expose you to these are the forms of dispute resolution that are available to give you solutions that are binding, that preserve relationships, and keep the wheel of economy going.
Asante Lawrence. John, last but not least, please let us know who you are, what you do. You need to unmute your mic, sir. It happens to
Well, that's always a difficult. That's always a difficult question for me, but let me try. So I practice law. I'm a senior counsel. I am the managing partner in the firm of OK Law LLP, and I am the co-head of dispute resolution in that firm. I am a litigator. I'm a chartered arbitrator. I'm a mediator. I chair the Sports Disputes Tribunal, as many people would know. I also sit on the board of the Nairobi Center for International Arbitration. I sit on the Mediation Accreditation Committee, and I chair the National Committee for the formulation of the ADR policy. So that's just a little of what I do within, the dispute resolution space.
Oh, thank you very much, John. To our viewers, obviously, we're going to get to know more about our guests. You've heard what they do. Let's see what they actually mean when they're talking about all these things. I'm going to use the word ADR through the show instead of saying alternative dispute resolution, because that's going to be a mouthful. John, I honestly thought I heard you say you're a singing counsel. Kumbe, you said senior counsel. I was like, okay, fine. I'd like to hear what a singing counsel looks like. So let's kick it off. I want to start with Mercy with this question, yeah? What are the various methods that make up ADR as a whole?
Well, ADR spectrum as it is very wide, such that perhaps just by definition, when we mean ADR, we refer to methods of resolving disputes that are outside litigation. And there are so many of them. However, I will just mention the main ones, the ones that you come across at what point in your dispute resolution life. There's negotiation, mediation, conciliation, early neutral evaluation, expert determination, dispute review boards, and mediation, arbitration. Those are the main forms, basically in a nutshell.
It sounds like there are quite a few, by the way.
There are many. What I'd say is was to narrow basically the main ones that at least every Kenya has heard of is negotiation, mediation, arbitration. If you were to speak to the person in the street. Yes.
Okay, cool. Lawrence, I want to ask you this question. What is the principal advantages of resolving disputes through the use of any ADR forms as opposed to the conventional court system?
On that broad spectrum that Mercy has alluded to, you could look at them from the ones that are closest to the court and the ones which are farthest from the court. And the pros and cons will change the farther and farther away you move away from the court. But I can highlight some of the common pros, for instance, saving in costs, saving in time, flexibility, party autonomy. You get to select the person who will facilitate the process. You get to determine the process itself, the amount of time you might spend on a process or the entire process, where you're going to conduct the process. So if it's mediation, arbitration, you get to select the venue. You could even select the rules of evidence. You don't get bound by the normal rules of evidence. And you determine whether to do it in private, or to the extent to which it can be public. So within that spectrum, all these pros will be manifest in any one of these dispute resolution processes. So I think the primary benefit, cost, time, flexibility, creativity in the outcome, and at the end, of course, preserving relationships. It allows for parties to continue with their business, for instance, if it's a business dispute, whilst they resolve the dispute. Think about not queuing. So if you go to court, one, you don't determine the judge, you don't determine the time you'll be heard, you get to queue behind other cases. And so those are some of the kind of benefits you get from alternative dispute resolution, irrespective of the process that you select.
Yes, Lawrence. John, can I ask you a quick question? Something that Lawrence had mentioned there, and you can expound on this. Mediation and arbitration. I think a lot of us would assume that they're the same thing, but there is a difference, or so I've heard. So what exactly is the difference between mediation and arbitration?
Or if you just allow me, let me just reframe, because we always think about it as alternative dispute resolution, but right. More and more I'm beginning to think about it as appropriate dispute resolution. What is appropriate to dispute? Then it's still ADR, but you substitute appropriate for alternative. Now, to answer your question regarding the difference between mediation and arbitration, Very simply, in arbitration, you have a third party who decides your dispute. In mediation, you have a third party who facilitates the two or more parties to decide their dispute. The mediator does not decide the dispute for you. He just creates the environment and gives you the tools to enable you to reach an understanding as to how your dispute is best resolved. So that's very simply the way I would differentiate those two mechanisms.
So what's the you said, you just mentioned it, but what, if you can go a bit deeper into what actually is the mediator's role?
So a mediator is actually trained. A mediator is trained to assist the parties to communicate, to package their disputes, and to be able to communicate their disputes in the best way possible. So a mediator's role is to bridge the gap between this party and the other party. And the mediator will do that in several ways.
Mm-hmm.
So, for instance, a mediator may rephrase the way that you have you've brought your dispute about so that it is better understood by the other party. A mediator will help you to understand the other party's perspective. There might be cultural differences, for instance, or there are many disputes in which you're actually both right. But because you've got difficulties in communicating, because you are in dispute, the mediator will act as your bridge. So that is why a mediator needs to be specifically trained as to how best to assist parties in dispute to communicate with each other. A mediator may, for instance, take one party aside and better understand the nature of their dispute and then bring it back into the forum and relay the dispute to the other party. So mediator has to be very skilled in balancing the interests of both parties and being able to understand the nature of their disputes, the genesis of them, and where every party wants to get in their journey towards resolving the dispute. So that's it's a very delicate act, but I hope I have helped you to understand what it is.
Absolutely. I'm going to come back to the aspect of the training in terms of mediators and arbitrators, specifically more actually about mediators. But Mercy, I want to ask this question based on what John has just explained to our viewers. Can you combine mediation and arbitration?
Well, usually in practice, the most common ways that mediation and arbitration happen at around the same time is where parties, it's called med up. From the main forms of alternative dispute resolution that I mentioned in the beginning,
mm-hmm.
There's a method called med up. Basically, it's a combination of mediation and arbitration, so that a party may pursue mediation. And since, as Mr. Ohaga has explained, mediation is not as stringent, as formal as arbitration, such that the mediator's decision does not matter in terms of binding the parties. If parties feel that mediation, if they don't reach a settlement, they could then move to arbitration. So they can provide that, let's try mediation first. If it doesn't work, then we move to arbitration. However, in some instances also, you can actually just decide to go to arbitration. And when you go to arbitration, nothing precludes you or nothing stops you from going to mediation. Now, the issue is this. In practice, it is highly inadvisable that the mediator that was your mediator is also your arbitrator or vice versa. You know, mediation is more informal and is not as binding in terms of the process and formal as arbitration. So that if I am your mediator and I get things and I hear very confidential information during mediation, because mediation is more of a kufungua roho process, if I could say so. If I'm going to bind you by my decision as a judge would in arbitration, then that will become tricky because I'm already privy to information that I got from being acting as mediator. But there's no issue with either starting with mediation. If it fails, you go to arbitration, or even you start with arbitration and go to mediation, and even you can still come back to arbitration. So you can do both processes, but they can't. Basically, it's highly inadvisable that you choose the same person to act as mediator and arbitrator.
Thanks, Mercy. Lawrence, let me come to you. And something I picked up on what Mr. Ohaga said, as Mercy called him, I just call him John. Mercy seems to be standing on formalities. So according to Mr. Ohaga, I wanted to find out, in terms of the mediation aspect, does one need legal representation in the process of mediation?
Well, let me begin by mediation. As I mentioned earlier, mediation as one of the processes gives room for creativity, flexibility, and party autonomy. And one of the things you get to select is whether or not you will be represented by a party. And that representation may be by legal counsel for legal advice. It may be a dispute that has minimal legal issues. And so, for instance, construction, you may want to be represented or accompanied by someone who is more accustomed to the practice of construction. So yes, in mediation, you have a great latitude and creativity, of course, subject to agreement by the other party and the mediator, to allow for representation, not merely by legal counsel, but also an expert from any other field to specific.
I think we've lost him.
It can be
just lost
a friend.
Oh.
Sorry.
Okay, we lost you there slightly, Lawrence.
Okay. Am I back?
Yes,
Yes.
you are. Yes, you are.
All right. So the representative could also be someone who just makes you comfortable in the room. So a friend. Think about a family dispute, a dispute that has sensitivity of family relationships, and just could be that person who gives you the comfort to be able to participate, to balance the power in the mediation. So yes, there's a great latitude to allow for either representation or accompaniment to someone who facilitates the process to move as it should.
Thank you, Lawrence. John, I want to ask this question, and then I'll come to Mercy. So it's a twofold question. Number one, what types of cases are suitable for mediation? That will go to John. Mercy, I'd like to ask you what types of cases are not suitable for mediation.
Yeah, well, most cases are amenable to mediation. So let me say that, for instance, I would say that cases involving family relations are suitable for mediation because you want to maintain confidentiality, you want to try and preserve relationships, and you want to be in an environment where you can express yourself as freely as possible. A lot of commercial disputes are actually amenable to mediation. Even $1 million disputes are amenable to mediation. What a lot of people don't realize is a lot of commercial disputes actually involve more than just the factual situations. There are also egos involved and so on and so forth. And so those will be amenable to mediation. Disputes relating to employment relations are also amenable to mediation. I settled a dispute, as some of you may have seen in the public domain, about 3 years ago. This was the doctor's strike. That was an employment-related dispute. It was a dispute between the doctors and the government and their terms of work, conditions of employment, and so on. And we were able to resolve it through mediation. Disputes around land, even though land is a very emotive issue, but those are also amenable to mediation. So that's a whole category of disputes that you can really resolve around. Intellectual property is also amenable to resolution by mediation. So there's a whole range of disputes that you can actually determine through mediation.
Excellent. Mercy. So is there a plethora of things that you cannot do in terms of mediation, or is it a bit more restricted?
I would say something that my lecturer in campus told us. You know, you don't ask, the question is not can you sue? The question is, can you sue successfully? So you can refer anything to mediation. I mean, it's your oyster, it's your choice. However, there are some things, no matter how much you want them to be mediated, it's not possible. For instance, issues involving interpretation of legal let's say, rules. For example, I'm trying to think of an example. Say you've been discriminated somewhere and you want to go and pass, even let's use the case of the Rastafarian. the one who was told they have to remove their Rastafarian turban basically before they can attend a certain school. You see now that is a constitutional issue. Even if you want to take it in mediation, the rights which you seek are under Article 27 of the Constitution, under discrimination of rights. So that a mediator cannot pronounce him or herself on issues of legal precedent. So such matters that involve interpretation of legal issues cannot be mediated because a mediator does not form precedent. A mediator, things like election petitions, you can't ask a mediator now to decide who won Nairobi County elections in 2017, you know. Anything that involves interpretation of legal rules, you cannot move it, refer it to mediation. Rather, you can take it, but as I said, successfully, not really, because the mediator has no jurisdiction. Issues also of rights protection. When you think around, when maybe even, let's say even the Security Amendment Bill, when there was a lot of backlash from Kenyans around it being unconstitutional, and people were saying some rights are being protected, issues of police brutality, such things you cannot, Bill of Rights, you can't take them to mediation. The mediator does not have powers to pronounce themselves on such issues. Also, criminal cases largely, even in Kenya currently, the practice is issues of sexual offences act, the whole act generally, and criminal offences, anything that falls under the penal code is not taken to mediation. However, in Kenya, there's a system called an alternative justice system. The policy was launched last week, but last week by the Chief Justice. The only way criminal offences can be taken to alternative justice systems like a process outside court is, so far, in Kenya, it's only been in 2 capital offenses that I'm aware of, 2 murder cases, where the clans in I'll say the Kushites, the ones who are Kushites, since in tradition they used to resolve murder disputes because they are saying our person is dead, even if this person is sentenced to life imprisonment or hanging, or a person won't come back. So they resorted to traditional justice. But justice systems, that is now the clan sat and they decided the value of the person who died, and the court allowed that process. That is still not established law in Kenya, so that generally criminal matters are not taken to mediation in Kenya. Also, lastly, I think issues of trade secrets, you know, the same way we don't have a CIA in Kenya, but not everything is public information, even by government. So even if it's a matter that can be mediated, if it involves leaking things under the Official Secrets Act, and even sometimes it doesn't have to be so much public secrets, state secrets rather, as they were. It could be a big company like Safaricom, which is the highest earning, and some secrets cannot be known to the public. So such matters, they may want to not mediate them, not very suitable. You can take them to mediation, but they're not very suitable. Lastly, mediation is a process that one of the tenets of mediation is the aspect of good faith, where you know from the beginning that there is no good faith on the part of one of the parties, in terms of either one party has so much like there's power imbalance that cannot be balanced even by a mediator who's skilled, or even where you know for sure, or it is somehow can be established that one of the parties is using mediation as a way to either delay proceedings or delay the other person's rights, or even to intimidate and find information so that they can kill the other or ruin the other party's side. At that point, it may not be the most suitable process. You are better off maybe moving to a more binding or formal process. Yeah.
Thanks, Mercy. Lawrence, I want to ask this question, and there's been a lot of talk about mediation, but then I, as a client, assume I'm a client. What do I need to do in order to prepare for mediation?
Okay. One, you obviously have someone that you are disputing with. So there are 2 disputants, yourself and someone else. Mediation has to be consensual. So there has to be a form of agreement between you and the other party to bring whatever dispute you have before a mediation forum. So the very first point is to give mediation an anchorage, which in most cases is through an agreement. That agreement could spell out a couple of things. Other than the fact that that dispute will go to mediation, it may determine how you will select that mediator, how you will appoint the mediator, If the mediation is supposed to be run by an institution, so for instance, the Nairobi Center for International Arbitration, that also gives you the room to select the rules or procedure that shall govern how the mediation will be run. You will agree on issues to do with costs of the mediation, costs to be paid, the fees to be paid to the mediator. And then from there, you will embark on the process of actually now implementing that agreement. And this could take the form of one, for instance, if you're the claimant, you want to make sure that you have all your paper trail, if it's a paper trail based mediation dispute, before you can then lodge your request for mediation. You want to know what qualifications you want from the mediator, what other character aspects of the mediator you may have in mind as you start to select the mediator. And then, of course, look out for service providers who have mediators on their list. If it's construction dispute, you might want to look for a mediator who may well understand the kind of dispute that you have and the like. So it starts with the agreement. The agreement spells out what is necessary for the mediation. Before then, you activate the process itself, selecting the mediator. Important so that you also manage the aspect of time. If it's a dispute to be based on paper trail, each of the parties has within themselves their docket of paperwork that will eventually get to the mediator. So some of the things that you want to think about before are those.
Thanks, Lawrence. I'm going to ask John a quick question. Then we're going to go into a quick break where we're going to show you where you can actually get ADR services in Kenya, which I didn't actually know about. I just found out about it now. There's something that Lawrence had mentioned at the very beginning in terms of the flexibility and the quickness, or the quickness of being able to use ADR. But there's some other things that come through in terms of the fact that arbitration, or it's assumed, or it's not assumed, it's somewhere where it says that arbitration is becoming more increasingly costly because the more experienced lawyers are now getting entrenched in the whole system. Is that actually the case? While we say that arbitration is quicker and it should be less expensive, are there instances where now arbitration is becoming just as expensive as litigation?
Well, it's actually a question of how you compute expense. And it's also the level at which you are entering into arbitration. So there is international arbitration, for instance, which is not cheap. And then there is a domestic arbitration. And with domestic arbitration, it depends on the value of the nature of the disputes that you have. Now, if you are a bank, or if you are a commercial entity that is involved in a dispute that is before court, and that may potentially take 7 or 8 years in court, then what that means for you is that every year you're having to provide that amount in your books because you're now required to. And therefore, you have to take it out of your profit. You cannot assume that you will win that dispute. So the time factor makes it very expensive. The way in which we therefore look at arbitration as commercial arbitrators is to say, if you enter into an arbitration that you will be able to resolve within a year or a year and a half or 2 years, then you are having to look at a shorter time span, and therefore you are more willing to pay a premium in order to be able to resolve your dispute within a relatively shorter period. Now, the nature of arbitrator that you choose will also determine how expensive the arbitration could potentially be. And arbitrators are at different levels. There is members who are just that's an entry level. And then there's fellows of the Chartered Institute or whatever other institute it is that you belong to. And then there are chartered arbitrators who are at the top, of the totem pole, so to speak. And those will then charge you significantly more. So the reality is that it depends where you enter, it depends what you negotiate, and it depends how long you take before the arbitrator. When I sit as an arbitrator, I always tell the parties, the cost of this will really depend on you, how long you take, before me. If you want to take ages and ages arguing your case, then it costs you more. But you can go in quickly, finish, and get out. And that means that you could take a relatively shorter time. So the benefit with arbitration is that to a significant extent, it is in your hands. The control of it is in your hands because you as the parties employ the arbitrator. And therefore you determine what it is you can do and not do before the arbitral tribunal. That's, I think, hopefully a way that balances the considerations that go into determining cost.
Mr. Ohaga, I don't know, this is probably a conversation I'd probably just like to add on to what you've said. And I really would like to emphasize on the issue of being when doing your research when you pick an arbitrator. If your pick arbitrator is pragmatic, most of a good pragmatic arbitrator will try to move your matter within basically considerable time. Another comment is the issue of lawyers and lack of training, especially in this jurisdiction. Sometimes they fail to understand that arbitration is not the same as litigation, so that you want to basically save time. The reason you want to move to arbitration is so that you can save time and also make it a bit more flexible for your clients, so that you sometimes to relax your litigation part a bit. And I think there's a need to train lawyers. Lastly, in terms of research when picking the arbitration process, look at things such as expedited procedures. Because if it's a small matter with a small amount, basically the dispute is for a small amount, there's no need for you to go a full hearing and all that. You can look at having a document on the arbitration, expedited arbitration, and even sometimes you can actually basically get a double sum in terms of fees. So you have to do proper litigation so that you know which arbitrator are you picking, what is their usual style, such things, what is their general cost. Because if you don't research and you end up with a bill that's larger than life, also it's on you. Lastly, based on my research on issues of arbitration, which I agree totally with Mr. Ohaga in terms of it being compared to what is cheaper when you look at complex matters, you realize that in the United States, the practice of litigation, there's a lot of depositions. It takes months and months for a trial to be basically to even be set for hearing in court. And that is why in the United States, arbitration actually has been seen to be slower, because there's a very huge difference even in terms of practice between arbitration and litigation. So that's a distinction that needs to come in this jurisdiction so that it's not now as expensive as litigation. So you end up wondering, why didn't you just go to court where you don't have to pay the judge? So those are matters that need addressing. And increasingly, bar bench committees, even Mr. Ohaga is part of this initiatives, training lawyers and just sensitization even to clients and parties as to how to approach arbitration so that its cost is effective as should be generally. Yeah, that's all I can add.
Thanks, Mercy.
Okay, that's Ugambi Paul. Following now, I have a video to play. There we go.
Being successful in a tender application is every supplier's dream. However, when the payment from a purchaser remains pending for over 300 days, the supplier suddenly finds themselves in a nightmare. What happens when services have been offered, but the purchaser keeps extending the pay date? You could run to the courts, but they currently have a backlog of pending cases. Is there another alternative? One that is a legally binding or enforceable and proper to dispute resolution? Welcome to the Nairobi Center for International Arbitration, NCIA, an arbitral institution which facilitates parties to resolve disputes away from court litigation. Among the dispute resolution mechanisms offered at the center is mediation, where, through a mediator, independent third party, who facilitates the parties to find their solution to a dispute in a confidential and well-structured process. One of the facilities at the center are the state-of-the-art hearing rooms, which offer a private and receptive venue for the dispute resolution mechanism. The NCIA invites parties and practitioners to utilize the hearing room at an affordable fee. The center offers training and accreditation for mediators and arbitrators and educates the public on arbitration as well as other alternative dispute resolution mechanisms as provided in Section 5 of the NCIA Act 2013. The training in alternative dispute resolution, ADR, is open to anyone who wants to learn about dispute avoidance, management, and resolution. Our trainings are held in ultra-modern training rooms and are led by expert practitioners in alternative dispute resolution. The trainings can be tailored to sectors and to individual clients. Training with us gives the trainee high-quality assessment standards, access to leading practitioners in the field of ADR as tutors, as well as expert design materials. Granted that justice delayed is justice denied, the NCA now stands to alleviate the delay, taking cases that would otherwise be among the many still waiting to be heard and providing efficient and affordable alternative forms of dispute resolution. This is the future of dispute management and settlement, where arbitration and alternative forms of dispute resolution offer you a less conflictual experience, so you can get on track to achieving your dreams. The NCIA, where disputes meet resolution.
So it's a phrase that says you learn something new every day. And
Yep.
yeah, I've learned something new because you know, you always see it like, okay, I suppose because of the way the media works and the way they show you all manner of series and series about lawyers, like Danny Crane and whatever. They never show you any series about people who do arbitration. You know? It's always about, I'm going to sue you for this amount. This is what I'm going to get because of suing you, and this is what you did wrong, and it's just all sensationalized and everything. And obviously, there's obviously a way to do it that's not as hardcore. At least it doesn't look like you're going for the jugular. So that was interesting to say. I'd like to ask our guests if they have anything to add about NCIA.
Well, Overo,
Yes.
Masti.
I was going to say, so Haga sits in the board and you're the CEO, so perhaps as an independent user, I should speak first.
Go ahead.
Okay,
Because
let's have you, Mercy, then we go have Lawrence.
Not like you're going to say anything bad, but really, I'd say this. There's this survey that was published, the First in Africa Arbitration Survey, and it had very many respondents. Now the number is just quickly lost on me. 354 actually from Middle East, Asia, Europe, and Africa. And NCIA, the Nairobi Center for International Arbitration, was listed as one of the top centers for resolving disputes in Africa. And it's our own homegrown institution, and the facilities are top notch. I'm aware of that. And I'd encourage anyone, just go for a trip there. They always give you free tea. Just go and find out what they do, how to be a practicing person there, how they can train you. They're very friendly. So I think also in terms of building our own institutions, which have already been applauded by the arbitration community and mediation community worldwide, it would be apt to just pay a visit. You've seen where it is, Cooperative House. Yes. That's all I'll say. Now, Mr. Ngugi and John, now I was told I'm being too formal. John can now blow their trumpet.
Okay. I'll allow my employer to go first. John.
Yeah, as Marcy says and as Lawrence acknowledges, I sit on the board of the Nairobi Center for International Arbitration. You know, when you are formulating a dispute resolution forum, such as the Nairobi Center for International Arbitration. I think one of the benefits that somebody like myself, for instance, would bring to that exercise is the fact that I come in the first place wearing the hat of a litigator who has been in the trenches acting for clients for years and years in disputes that have started in the magistrate's court and ended up in the Court of Appeal. And you know the frustrations that you face at every stage. Then I wear a different hat as an arbitrator because I also listen to people's disputes. And I'm therefore able to determine what is it that people would like to see in an effective arbitrator. And then I bring the experience that I've gained from the Sports Disputes Tribunal, for instance, because sports disputes are very emotive as well, as you might have recognized in the media and other fora. And so when we sit at the Nairobi Center for International Arbitration, the thing that occupies our minds the most is how do we put together a framework, rules, an environment, a culture, a forum that would best lend itself to assisting parties in dispute to resolve their disputes in the best possible way. But also, how do we ensure that we, while recognizing what is best practice in court, avoid the pitfalls that courts often encounter in the way that they run their processes. So when you bring together professionals who have that experience and who are able to formulate their thoughts, then you are able to put together an organization such as the Nairobi Center. And I think that when you look at our rules, both for arbitration and mediation, when you look at our hearing rooms, when you look at the fact that we also engage in training, sensitization, you will see that we try to bring the best to dispute resolution and to make it as effective and as friendly as possible for people in dispute to come to us and to benefit from the environment that we have tried to create there. Lawrence, maybe now you can go.
Okay, thank you. Let me just add, one of the things that Wawero you mentioned at the beginning is awareness. Although these services have been there for the longest period, not many people would be aware that they can resolve a dispute otherwise than by going to court. The general mantra is, let's meet in court. So NCIA brings the practice of ADR to a place where it can be accessed by the majority, that is the public. One of the things that has been the challenge with ADR was fragmentation. So we haven't had for a long time a focal point or a central point where all these dispute resolution processes can be customized, developed, international best practice brought in, what international arbitration does bring in. We both offer domestic ADR and international ADR. So assuming the party is in Singapore or another one in Thailand and someone is in Nairobi, they have a contract. That contract is actualized in Uganda. How do they resolve the dispute? Nairobi Center for International Arbitration brings in not just the domestic element of dispute resolution, but it links both the Kenyan and regional parties to an international practice that has been also running for about 100 years. And as Mercy mentions, through this independent survey, we have been now ranked among the top 5 similar centers on the continent in dispute resolution. So what we are providing is orderliness, reducing the gap of awareness about these dispute resolution processes, and therefore providing a professional service whereas before ADR had been largely ad hoc. Parties would organize their own mediations and arbitrations. Now you have a one-stop shop where you can devote your time to the actual mechanics of putting together the evidence, bringing the evidence before the tribunals or the mediator, and we get to handle the administrative bit of running your dispute.
Okay, I'm back. I'm going to need ADR with my service provider, so I'm going to have a chat with one of you after this. So there's something I wanted to pick up on that Mercy had said. I don't know, Martin, whether you asked this question when I got lost. You had mentioned the fact that you can actually go to NCIA and you can actually get trained, as in it's a certified course. How much does it cost for people who might want to say that they have the gift to be mediators or arbitrators or whatever the case may be, unless I misheard you?
Sorry, well, you see, I don't know the exact cost of NCIA, but they're all on the website. What I know is that the entry course in arbitration, they train in arbitration and mediation. I know the entry course for arbitration is coming up in, I think, the next 2 weeks, and it's 20,000 shillings. But then the only two organizations in Kenya that train in arbitration are Nairobi Center, the NCIA rather, when they say NCIA, and the Chartered Institute of Arbitrators. As for mediation, NCIA also trains, Chartered Institute of Arbitrators trains, Strathmore Dispute Resolution Center trains, what's this? Mediation Training Institute of East Africa trains, DCRI. There are about 6 leading mediation, basically not leading, I won't say leading, but 6 most common training institutions in mediation. But I wouldn't want to say leading because I don't want to spoil anyone's business. But yeah, arbitration is only Nairobi Center, International Arbitration, and the Chartered Institute of Arbitrators. All courses anyway for all these institutions range between 20,000 to 100 and maybe 60,000, yes. But then you see, mediation is not a one-day training. There's entry course, there's also 40-hour, and also arbitration has its various stages. So depending on the institution you choose, per level, let me say per level, you pay between 20,000 to 100,000 per level, depending on the institution that you choose, for either mediation or arbitration.
Thanks, Mercy. I'm now going to jump to John, and it probably relates to what I'd asked you earlier in terms of lawyers entrenching themselves or entangling themselves in arbitration. Is that a case of, or would it be created because it's assumed that lawyers will get less legal fees when they're doing ADR?
That's an interesting question for me, because I am an ADR practitioner. Right. I'm an arbitrator as well as a mediator, but I'm also a litigator. I have not experienced a drop in revenue. Any one of those. I think what happens is that when you equip yourself and you're then able to advise your clients on what is the most appropriate dispute resolution mechanism for their dispute, then your clients are better able to trust your advice, and therefore come to you. And the choice that you make is not dependent on the cost of the service. It is dependent on how appropriate that service is. I think the best lawyers will not advise you based on how much it will cost you. They will advise you on how appropriate it is, whether your case meets the threshold for success or otherwise. They'll warn you about the pitfalls and the dangers, and the length of time it could possibly take, and so on and so forth. So I think it really is how you position yourself as a legal practitioner. But I do think that lawyers are really, really well positioned and well trained to be arbitrators.
Okay.
And Mr. Walker,
sorry,
Mr.
please jump in.
Add something. I remember when I was young and looking for tutelage, and I remember coming to your office because, of course, I was planning to get into litigation, and also I was doing a bit of ADR. And it's something I picked from you. You may not remember, it was maybe 8 years ago, but I remember you saying that as a lawyer, you're not you're a dispute resolver. So that in your toolkit, like when you have a problem with an issue, in your toolkit you should have all these skill sets. Because when your clients come to the problem, they don't tell you, take me to court. They tell you, Wakili, how can I solve this problem? So that if you don't have the entire tool, all the tools in your toolkit, then you're first of all, you're misadvising your client because you're narrow-minded. And in any event, all this dispute resolution, when you sit as mediator, administrator, investigator, they're all income earning. You're even expanding your income earning potential. So I don't see any loss in it.
Actually, if I just add to what to what Mercy says, my first practice as a lawyer in relation to my clients is dispute avoidance. How do we avoid disputes? Avoiding disputes starts with the nature of agreements that you enter into, how you relate with the other parties, how you structure your documents, how you go about your business. Because really, clients have no joy being in dispute. Yeah? Clients come to you, once clients recognize that your first port of call is dispute avoidance, then they will come to you even before the dispute arises. They will come to you when they're entering the transaction, and they will ensure that the transaction is structured in the way that best avoids a dispute. Or if a dispute arises, how best do you mitigate the unfortunate effects of a dispute? So you start actually with dispute avoidance, and then you move on to dispute resolution. That's really the way that I think about it, because we're not really born to be in disputes. Nobody enters business to be in disputes. When you enter into a marriage, you don't enter the marriage to end up in divorce. You enter it to sustain it. So how do we ensure that our relationships are dispute-free? That's the first port of call.
I want to bring Lawrence in here very quickly and ask the question. So you've gone and you've chest thumped and you said, fine, I'm going to take you to court and, you've done me this wrong and I'm going to get back at you. And then you decide, okay, maybe we can now stop and let's go for ADR. Would that suggest there's either a weakness or you have a problem that you don't want to expose yourself to? So the question is, does proposing ADR suggest a weakness to any of the other parties or to the other person you're trying to resolve the issue with?
Wawero, I think to answer you, let's begin with who actually owns a dispute. If we were to answer that question, then we may be able to resolve whether there is one party who might look weak or strong.
Right.
If we redefine who really owns the dispute, we actually will find a dispute actually belongs to the real parties. And the unfortunate thing that we have ended up with insistence on litigation in court is that we have literally relegated the real owner of the court to the back burner. Disputes are no longer about the parties. So that even when parties themselves are thinking about their dispute, they forget that actually the dispute is theirs. And so they end up, in a sense, ceding control over the dispute to legal practitioners, to the courts, and the like. So let's begin there. Now, if each of the parties to a dispute understands that they actually own the dispute, they understand the dispute the best, and that they have, before they give it up to a third party, absolute control over how that dispute can be resolved and the outcome of it. I doubt the question of whether one is weak or not would arise. Does that deny the fact that there could be a situation where parties could consider the question of strength or weakness? Yes, there could be. So take, for instance, the example of unevenly placed parties. An extremely strong participant in a dispute, a multinational versus an employee or a smaller SME. There could be a tendency, depending on who determines the decision to go to ADR, to make it on the basis of either show of muscle or avoidance of a feeling of weakness. So yes, there could be situations where parties rightly think that they are either stronger or weaker as they're entering into ADR. But if they were to redefine the concept of who actually does own a dispute, there might be a clear understanding that one needs not to feel that they are exposing themselves to weakness by pursuing ADR. Ultimately, what do they want to see at the end of the dispute resolution process?
Where do we have you?
Lawrence?
Okay, while we're waiting for our maybe
Sorry, I keep dropping in and out. I hope everybody can hear me.
Online. Yes, this resolution online, especially in these COVID
Unfortunately,
times.
I'm cutting out.
Okay. I'll start. John can maybe finish. I'll just say it is of course in these times physical, at least now before the restrictions on the issue of curfews all over the world, the nature of dispute resolution and how it's conducted has changed. So that there's more use of online platforms, both in arbitration and mediation. But one thing that people don't realize that even before the pandemic, there were email services were also being used. People used to solve disputes using teleconferencing. There are also videos, teleconferencing, virtual, except that now these things have come to fore because of the COVID-19 pandemic. Another area that people have actually to take to understand now is that these issues of Jumia online, buying things off eBay, the dispute resolution mechanisms in there are online. There's no day you'll go to a mediator. It's online, and in fact, they are moving even to use artificial intelligence, so it won't even be an actual human using it. So that's the course in Kenya. The course and next mediation program right now is looking to move to online mediation, and a few arbitrators have been conducting matters online. But then now this is the issue that increasingly has to be developed, and there's been a lot of discussion in the ADR community rather, as to how we can improve our technology and come up with rules that now bolster this system of virtual and online dispute resolution, because right now it's being used more than ever. It was there, but now it's become a must that it's being used. Yeah. Maybe John can add something. I had to speak really fast.
I mean, yeah, I think Marcy has captured it. You know, as commerce moves online, you know, even before the pandemic, you had more and more people purchasing goods online. There's Amazon, there's Apple, there's Jumia locally, there's Uber. What has led to a situation where those entities which are promoting online commerce have recognized that there will be disputes relating to the products, delivery, quality, pricing, and so on. And so they have had to establish an online dispute resolution mechanism, which means essentially that you send them the nature of your dispute, yet within themselves a separate dispute resolution which will look at your dispute and determine it. Send you your balance or send you a refund, whatever it is, but they will make it cheap and quick. And that's really what online dispute resolution is. Of course, as arbitrators, we're also more and more now resolving disputes using virtual platforms like Zoom. I've now just discovered StreamYard. I don't know whether it is possible to use it to resolve my disputes on this forum or to hold my hearings on this forum. But Microsoft Teams, all these are becoming available to dispute resolvers to use. And so technology is really, really coming in a big way to assist dispute resolution. And then there is artificial intelligence, which is a whole for another hour or two.
Thanks so much, John. We are winding up, but as usual, we like to extend because we're having so much fun. And I'm sure there's a lot of people who want to actually now really engage from this perspective. But then I'm going to ask Mercy this question, and there'll be another 2 or 3 questions we're trying to ask before we wind up. Mercy, I'd like to ask you, how do you choose an ADR practitioner? Do you just comb through a phone book and say, okay, fine, I want a female who's 5'7", who does ABCD, drives a BMW, nake, all that kind of stuff?
Well, if I drive a BMW, I'm gonna charge you more per hour because those parts are not cheap. Okay. Well, you see, when you choose an ADR professional, be it a mediator, any of that third party I spoke about when I mentioned the types of ADR and the forms rather, the first thing you have to look is the track record. Basically, what in the community are they finishing their matters, and what do their peers basically, like you see the way Mr. Haga is senior counsel, what do their seniors say about them in the ADR circles or their peers rather? Also, you have to look at the issues of experience because every dispute demands a certain type of experience. And as such, based on your dispute, you have to see what level of experience do you think will need for a person to resolve this dispute. If it's something like 100,000 or a small, not complex legal matter, anyone with at least 3 years can do it. But if it's complex and involves complex issues, you have to look at it. Also, subject matter expertise is something else. Because if your issue involves issues of, say, strong oil and gas, pure and pure, it will be better suited if you pick someone who has expertise, subject matter expertise in that area. So look at the expertise also. Another thing is also look at the school of thought, because if someone is going to be writing a binding award, and even if it's a mediator who's not going to write an award, you have to look at what do they think. For example, and this is a bad example because it's neither here nor there, but if you know that your client is a homosexual or a person who's in the gay rights movement, and you know the mediator you're picking is a staunch Christian who'd never hear or an arbitrator, also look at their biases generally and their personality. What are their schools of thought around issues, even issues of law? Are they conservative? Are they flexible around legal rules and such things? You also have to look at the personality actually in mediation and even in arbitration, because it's a flexible process and this is not a judge. You wouldn't want to pick someone who's so difficult, will not give you breathing space. Why? And you're paying them by the hour. Interpersonal skills also are very important because you also want to look at someone who's easy, relaxed, because this is ADR. You also not now that too relaxed that will be run over. They have to, of course, have the experience and expertise, but you have to look at that. Also, cost. Some people are more experienced, but they tick all the other boxes, but they're willing to negotiate on issues of cost. So that is important that you look at. Another thing also is their style in terms of how they conduct themselves, in terms of proceedings, how they treat parties, how they treat counsel representing parties. And all this information, you just have to investigate the arbitration community, Google their LinkedIn profile. You may ask them for CVs. You are actually allowed to interview them if you need further information. Lastly, look at issues of integrity, because integrity is key. This is a person, if it's an arbitrator, you're trusting to write an award. If it's a person who takes pesa kidogo here, corruption and there, that's why you have to do proper research. But with a mediator who clearly sometimes has been held to be biased and has been proven to be biased, you don't want to pick such a person. So just on the base, basically, those are the things that say are very important in picking either any of them, mediator, arbitrator, any third party helping you resolve the dispute in ADR. Yes.
Lawrence, I want to ask a question, picking up on what Mercy said there. The word binding. Are ADR settlements binding?
Okay, well, it depends on the method. So if it's arbitration, the outcome will be an award. An award basically settles and binds the parties to the terms that the arbitrator has determined in the award. What do the parties do with it? If it is honored, well and good. If it is not honored, the party who has the benefit of the award moves to court to have it enforced, and there's a legal framework to allow for that to be done. Let's think about mediation. Mediation, on the other hand, is not binding. If parties don't agree, so that there is no settlement agreement, the mediator has no power to force the parties to a settlement or an outcome. All is not lost, because even if they have not settled, in many ways, mediation can result in a better understanding of the issues that were in dispute, even between the parties. It could result in partial agreement on some of the issues that were in dispute, so that it may not be full resolution of all of the issues, but they could even settle on some of the issues. And then for the issues that may remain outstanding and unresolved, they have the option of going to litigation, but on limited issues. So in some mediations, the fact that there is not a settlement at the end would not in itself mean that it was a loss. Parties could still reduce some of the issues and move to arbitration or litigation. So it depends on the method.
Thank you very much, Lawrence. In the interest of time, and I want to ask for parting shots. I know there's some aspects. If there's anything you would like to add on that we might not have picked up on, or you just thought about now and you're listening to each other talking, please feel free to add it. But I'd like to ask your parting shots with regards to today's very engaging conversation, actually, on ADR. And I like the word appropriate dispute resolution as opposed to alternative. I think appropriate makes, we should coin that. You should trademark that so that nobody can use it, or if they can use it, you can go to ADR to challenge it in terms of IP and all that kind of thing. But I'm getting ahead of myself. But yeah, that's a nice way of putting it. So I'd like to start ladies first. Mercy, what is your parting shot with regards to ADR?
Wow. Okay. Well, my parting shots are they're usually many, but I'll try and keep them very short. I would just like to tell the listeners that nothing stops you from pursuing ADR at any stage of your dispute, so long as there is no judgment. Even if it's a matter that is already in court, you're at liberty to request mediation, or even if it's arbitration. But at that point, maybe the other party may not agree with arbitration so much. But yes, you are able to get into mediation before the dispute, even if the dispute is in court. Also, there is nothing that stops you from going to the court annexed mediation registry and saying, I have a case here and I want to see whether this case can be referred to court annexed mediation. Because as you've heard, if you have a case, it's not a must that you settle. You just go and try. So there's nothing that stops you. Don't be those people, if you're members of the public, that you leave everything to your lawyer. Walk to the court, ask for your case number, and find out if it's a matter that you can go to court. Secondly, nothing stops non-lawyers from training as mediators, and nothing stops them as practicing as mediators or even arbitrators. From the training institutions that you've had, you can train even if you're not a lawyer, and you can sit as either arbitrator or mediator, or even for your own information, and also to help in grassroots and community, training, and even peacemaking and conflict avoidance and resolution. I was happy to be part of this panel, and I look forward to engaging further with anyone else who would want to. Thank you so much.
We always threaten, and we'll make true on that threat. Hey, wow, I thought I'd made it through the show. We'll make it true on that threat. We always tend to want to have a part 2, and we will have a part 2 as I continue stripping and striding. Lawrence, what's your parting shot?
Well, it has happened. Let's move away from let's meet in court and to let us meet outside court. Anyone in a dispute ought to remember the dispute is in your control. The more and more you involve any other party other than yourself and the person you're disputing with, you lose greater control over your dispute. Look for the lesser conflictual methods of dispute resolution. And we as NCIA are there to provide a platform for you. If you are presently considering resolving your dispute, talk to us. We will let you look at the spectrum that is available to you so that you can not only resolve the actual dispute, but preserve relationships, continue business, actually even continue business as you're resolving your dispute, ultimately owning the dispute, the process, and the outcome. So for me, the dispute belongs to you. Bring it to where dispute meet resolution, NCIA.
Thank you so much, Lawrence. Last but not least, John, give us your parting shot, please.
I think both Mercy and Lawrence have captured it very well. I think I've just, in my experience, disputes escalate or can be de-escalated based on the communication that you're able to achieve between the parties. So I would say find the dispute resolution forum that best allows you to communicate to the other party, because that is the way that you will reach the other party and be able to attempt to the greatest extent possible to resolve the dispute in a way that is most advantageous to you. Disputes are stressful. The resolution of disputes can be very expensive. So therefore, recognize, as Lawrence says, that the dispute belongs to you. Do not allow your dispute to be hijacked by another party, the cost to escalate beyond your means, and the stress levels to be such that even by the time the dispute is resolved, you do not really benefit from that resolution. So I would say find the most appropriate dispute resolution forum, and that really is the responsibility that you have to yourself. Thank you very much for having us on this show, and I've greatly enjoyed myself.
As have I, and thank you to Mercy and Lawrence as well. This is why I love doing this show. Great Leadership Live always teaches me so many different things that, you know, it's absolutely amazing. I have a parting shot, Martin. And you know, it's my good friend on the computer. Right. It says, we cannot solve problems by using the same kind of thinking we used when we created them. That's from Albert Einstein.
Yes.
Yeah.
Correct.
I feel so
lovely. Because of that one, you see that this one I've been putting up. Occasional conflict is inevitable, but combating is optional. You don't have to. And I like what Lauren said. This phrase "see you in court" should be a thing of yesterday. And I agree with that a lot. Thank you, everyone. That was a lovely show. I mean, what can I say after?
Yeah, I'm thinking seriously. I want to do that and say, to be honest, and I'm going to look for Lawrence after this.
Yes, I'm still absorbing and processing the info, but it's been great having you on the show. It's been very informative. We have to have a round two. Well, we have to have a round two, but in round two, let's start with a little debate. I want to see them in their lawyers' hats, arguing a certain case. One for, some against. We do a 5 minute.
No, we do.
Courtroom scenario.
We do how to get away with murder scenario. You know the way? Okay, I don't know whether you've watched the series, but they throw in a scenario, and then these guys have to then come up with different ways in which they can arbitrate, and then the best person wins. Chooms or something like that. I can't remember, but yeah, that would be a fun way to actually do it.
Yeah.
Unless if we did a mock mediation or a mock arbitration, like with one of us sitting as arbitrator or mediator and the rest as parties.
Anyway, that's the second season of this ADR conversation.
Yeah. So I think at this point we close it. We close the show. We're 13 minutes above our regular timing, but I mean, time flies when you're having fun. When you're having fun and you've got so much to learn from. And I don't think even where we reached half of the questions we had.
No, we were struggling not to, there was quite a few questions that we had there.
Yeah.
I was trying to say the juicy ones. I wanted to use the juicy ones.
Yeah, I think the panel handled it very well, interweaving between each other. And
most definitely.
So for those watching, and the link, of course, I'll share the link shortly for the recording of the show. And I thank you once again for sparing this 1 hour to be on the show. And I'm sure you have opened many eyes, mine included, on this subject. So thank you very much, Wakilis, and hope to see you again very soon.
Thank you.
Bye.
Asante sana.